So finally, we get to meet face to face.
We do.
It's really, really nice to meet you,
And you.
Stuart, and these offices here in Bromley are absolutely amazing. But today we are going to talk about alternatives to court, because we tried to do this via Zoom and it didn't work, did it? So,
no, absolutely.
But anyway, this is much nicer to have a chat. So, talk to me about alternatives to court. What are they?
Yeah, well, I think most people know that cases can end up in court if there's a problem. But what a lot of people don't realise is that there are alternative methods to sorting things out without having to go to the court. So the most common ways are what's called mediation.
Right.
There is also something called collaborative law, and then you can also do something called arbitration. So, just very quickly, mediation involves appointing a third party to act as a mediator, and you'll have a few sessions with the mediator, and hopefully between the three of you, you'll be able to broker an agreement. Arbitration involves appointing a third party to effectively act as a judge to help you make a decision as to what the outcome would be. And collaborative law is where you both appoint specially trained solicitors to act as advisors, and through a series of roundtable meetings involving the two solicitors and the two parties, you hopefully manage to come to an agreement.
Okay, and so what are the advantages, I suppose, to those sort of three options and alternatives? What are the advantages of going down that route?
Absolutely. Well, there are several, actually. The first is that you're far more in control of the process, in terms of a time scale, what's more important to you, where you can focus the areas that need discussion and hopefully agreement. Whereas if you go down the court route, you then just find that you're part of a bigger process. So you retain a bit more control over the process. It's also a lot quicker and cheaper. Unfortunately, if you are using lawyers and the court system, the court is under enormous pressure at the moment. It is taking months and months for court hearings to be listed, and these alternative methods can be organised pretty much as soon as everyone's diary allows, so you're in control of the speed at which the process goes forward. So from a cost point of view, a timing point of view, and a flexibility being in control of the process point of view, these methods are really to be commended rather than just thinking court.
And what would your clients be going through? What would they come to you for to go down this route? Is it divorce? Is it, what can it apply to?
Well,
other things?
It can essentially apply to whatever people need help sorting out.
Right, okay.
Usually it's most beneficial when it comes to making the arrangements for children and also the financial arrangements. But it's particularly useful if some people have already agreed how certain things would work, but there might perhaps just be one or two things that they can't quite agree on.
Okay.
And so these alternative methods can just focus on the outstanding points that need sorting out, rather than reviewing the whole thing from scratch, as it were. So it can be bespoke and deal with as much or as little as needs to be sorted out.
Okay. So if someone watching this today thought, this sounds interesting, and I wasn't really aware of that, what steps should they take to discuss this in a bit more detail?
Absolutely. Well, basically, they just simply get in touch with me at Thackray Williams,
okay.
either by telephone or by email or through our website.
Okay, so an initial chat with you would go through the detail of this.
Absolutely.
And then they'd have the options presented to them and they could take it from there.
Absolutely.
Okay.
It's not for everyone, but it's an option out there, and for a lot of people it's a very good option, and one of the things we always do is explain all the options so that the individual can make the decision on what they feel is most appropriate for them.
Okay. Thank you for your time today.